Here's what a U.S. court cares about. Is the trust overseas? Is the liquid asset overseas, whether it's in a trust or an entity? And by the way, when you put assets overseas, there are reporting requirements and there are massive penalties, sometimes criminal penalties, for failing to meet the reporting requirements. This is tax neutral and you have to report it. This is purely an asset protection move. Here's the theory. There is a creditor and I disclose my assets to him. There's a judgment against me and we're in court, and under penalties of perjury, I disclose my assets. So I've got assets overseas. They're actually overseas, not in the US. I'm questioned by a creditor and they ask, give us a list of everything you got. So you tell them, I have this overseas trust and good luck getting at it. They're not giving you squat. Good luck. How does that usually go? Usually you have a lot of leverage. Usually creditors don't want to play that game. Usually they're willing to settle 10 to 20 cents on the dollar. Now, if you get a wealthy creditor or a highly pissed off creditor, or worst of all, a highly pissed off wealthy creditor, they do have an angle and it does work. They will submit an order to the court that you must be forced by court order to repatriate the foreign assets. Now, your argument will be, that's impossible. The judge then puts you in prison for contempt of court. In every one of these cases, almost every one of them, there was no prison time. The assets appeared, showing that the impossibility defense was fake. It was possible to repatriate assets. So nothing's bulletproof. This is Kevlar. It works a lot of the time, but Kevlar covers your chest and your arms, maybe your legs. It doesn't cover your face. You get shot in the face, you die. There are vulnerabilities to every sort of armor, including this one.